Farmington Hills Advisory Board together, and I'm glad to see him here today. Today, what I'd like to talk about is practical estate planning. So this is not a scholarly presentation, it's a nuts and bolts, how do we do it presentation. I think the thing to start with is to assure everybody that probate is no horror story today. Those cases which were disasters in the past are basically a thing of the past. Today, the vast majority of cases run very smoothly. A petition for probate is filed, a clerk issues letters of authority, the personal representative then pays the bills, pays the taxes, sells assets as needed, and makes a distribution. All he or she does at that point is file a certificate of completion, and if nobody objects in 30 days, the case is closed. Normally, the total time involved is between 6 months and a year, and it often can be just over 6 months if everything runs smoothly. Only if it is a problem does everything slow down. Family fights, contested creditor claims, tax issues can take years to resolve before an estate can be closed. One of the benefits of estate planning is to tell all family members exactly what you want. That goes a long way towards eliminating family fights. So we all need to plan before probate. Estate planning and administration goes on for life and beyond. Every adult, young or old, needs a medical power of attorney. Our chance of being in a hospital is a lot greater than being in a funeral home. Do your family a favor and tell them who can make decisions about your medical conditions. For my parents, they decided that my sisters were appropriate to make healthcare decisions, and my brother and I were appropriate to make financial decisions. Second most important point, your kids will forever be grateful if you keep a notebook of all your accounts and especially your passwords. Keep it up to date. So much time and money is wasted just looking for stuff. And don't leave your list of assets and passwords on your computer, which probably will be password protected, and so you can't get into the very information you wanted. Check your beneficiary designations on your bank accounts, investment accounts, and especially life insurance policies at least every 3 years. Birth, death, and divorce happen. We all have to ask ourselves whether we still like the beneficiaries we have named. All too often, we find that life insurance beneficiary changes were not made after a divorce, like it should have been. When a new spouse files a divorce, a death claim, she finds that she is out in the cold because the policy of insurance is a contract. The insurance company agreed to pay the person named in the beneficiary designation. There have been any number of court suits between the old spouse and the new spouse exactly because somebody did not follow through on beneficiary designations after a divorce. In terms of basic estate planning, for most folks, just putting all assets into joint names or naming beneficiaries on a POD account or payable on death, they do. But often that is just not enough. That brings us to the last will and testament. Wills, in shortest form, take care of loose ends. By that, I mean any asset that does not contain a beneficiary designation or assets were titled in joint names. The will names a personal representative who used to be called an executor and directs where to distribute available assets. In modern times, the will is often signed in conjunction with a trust. The will basically says distribute everything to the trust. That is called a pour-over will. So I think now we should move on to trusts. Basic definition. A trust is a fiduciary arrangement that allows a third party or trustee to hold and manage assets on behalf of a beneficiary. Thus, the trustee works under the specific instructions set forth in the trust agreement. All trusts are either revocable, which means they're living trusts which can be changed by the person setting up the trust, or fixed trusts that normally cannot be changed at all. The most common trusts are revocable trusts, which call on the trustee to provide for the remaining spouse and then distribute any remaining assets to the children at appropriate ages. This arrangement allows the maker to give instruction that he deems best for his family, including consideration of each of their financial strengths and weaknesses. These trusts can be very short. They can call for a short period of time. If all of the children are adults, often we simply say, as soon as the wife or remaining spouse is taken care of, distribute the money outright. But if the children are, the beneficiaries are young, or if there are special problems, the first thing to do is simply stretch out the payments to the children. If the children are somewhat young, if you were to give them everything, you know that they're going to buy a car first. So the thing to do is give them, say, a third as soon as possible. And the next 3 to 5 years later, and maybe a third installment by that time. And if they can't manage the money by that time, it's just lost. The other thing that the trust does is resolves disputes between children because mom or dad already told them what they wanted done. That solves any number of problems. When a family has a beneficiary with severe physical or mental handicaps, often a special needs trust is used. This is a trust that provides for ancillary care for the child over and above what governmental assistance there might be. It is totally voluntary on the payments. And then if there's any money left when the handicapped person dies, it can revert to the family. If you give a handicapped person the money outright, then the state will be able to force you to use or will recover any monies that are left. There are two kinds of special needs trusts. One set up by anyone other than that person, and that's the most protective. A person can also put funds in it as the handicapped person or incapacitated person. That money is more subject to the government getting their hands on it.
Oh.
And don't want to do that. Other kinds of trust, a domestic asset protection trust, in that the client retains certain interests while limiting the ability of a creditor to get at that. That's often used by professionals to protect assets against malpractice claims. There are all sorts of other minor trusts that can be set up. A trust for a family cottage, which is very important because part of the family will use it all the time and other part of the family won't use it hardly at all. And you want to avoid fights over whether who's going to pay for the expense of the cottage. And then there are little trusts like a pet trust or a trust for handling guns in the family. All sorts of trusts What we're talking about, though, in general, is the garden variety trust where spouses take care of each other and then give money to their children. Should a trust be used? A couple of factors involved. One, are there special needs in the family that you need management? Second, do you want to keep the estate out of probate? Basically, do you want not to have to file an inventory telling the whole world what your assets are? Second, if it's a minor, you may want to hold money in trust rather than setting up a guardianship for a minor. There are some disadvantages to using trusts. There is the initial expense. There's an obligation to monitor the assets every year to make sure that you're up to date. There are no tax advantages to this. And finally, since all assets may not be included in the trust, you still got to have a will. Cost, probably anywhere between $1,500 or $1,800 minimally. The sky is the limit. I think the money is well spent because it takes a third of the time to figure out what assets there are and plan how to deal with them if the grantor, the person making the trust, can make those decisions. Asking the children to figure out what the assets are and what to do with them becomes expensive. So this is money well spent in front to save money for the kids down the road. That's a quick overview, and I've tried to emphasize practical things to do rather than a scholarly review of the tax law and so on. But I'd be happy to answer any questions you've got, and let's see where we go from here.
Well, you mentioned taxes in passing, Jim, but if you have a trust, you have another taxable situation to consider every year, right?
As long as it is a revocable trust, which means as long as the client is still living, no additional tax. You simply ignore a revocable tax, a revocable trust for purposes of filing your taxes. If the trust is irrevocable, either because the client died or because you set it up that way as an irrevocable trust, then the trust becomes its own separate taxpayer with rates that are above what they are for individuals. So there is an expense there. What the government is trying to do is force distributions out so that there is no net income left in an irrevocable trust. Did that make sense?
Yep.
Okay. Good. Phil, any other questions?
Not from me. I have no idea where to start.
Where you start is sitting down with a pad and paper and writing down two things. The first thing is, what do I have? And the second thing is, what do I want to do with it? Because the good thing about estate planning is you're in control. You're in control through a will. You're in control through a trust. And basically, the only limitation on that is a spouse can make a claim against the will if she gets less under the will than she would get if there were no will.
Oh, okay.
So you understand that. But really the first step, write down what you have, and that's the list that I was talking about earlier.
Right.
It's bank accounts with the account numbers and the branch name, all of the stocks or other things, you want to write down if there are family knickknacks or family heirlooms that you especially want to go to this person or that person. And do a good job of thinking that through. The next thing you want to think through is, who do you want to be your personal representative? Who do you want to administer everything? And that's a tough question. It's an even tougher question when you think about a durable power of attorney for healthcare. Who do you want to ultimately make that decision on how to handle your care? One of the interesting things on healthcare powers of attorney is they're only effective, or they continue to be effective. Oh, no, I'll say it the other way. There's no power under a healthcare power of attorney unless the person is unable to act. And that may sound strange, but in the business power of attorney situation, they're drafted so it says, right now, the other person has a right to sign away my house and all my assets. Okay, and the reason that we do it that way, when logically would tell us it should say, if I become disabled, then the person who holds my power can take over for me. But if it's drafted as, when I become disabled, then the bank and others will say, we don't know if he's disabled or not, so you've got to go to court and get a court order.
Wow.
So you have to have trust in the person you name as your attorney, and you've got to keep it, your power of attorney itself, tucked away so that somebody doesn't improperly use it. Tough choice to make there.
You're in.
Okay. Well, if that's it, I will thank everyone for listening. If you have any questions, please give me a call. And good luck to the Rotary Club.
Hey, thanks, Jim.
Thanks. Bye-bye.
Thank you, Jim.
The rest of you can stay on if you want, or we'll call the meeting and go about our day.
That was a good review. Thank you, Jim. I
Thank
appreciate
you,
it.
Cynthia.
Very helpful. Thank you.
Okay, goodbye.
Okay, I will just end the meeting, and the recording of that, if you want to go back and hear again, in case you didn't catch it, which I will probably do, you can play it back and hear everything that Jim said and make your own notes. That should be up either sometime later today or early tomorrow morning. I will end the meeting. Anybody want to say anything before we go? Any notes, anything of interest? Yes, Penny.
You mentioned something about doing something a little bit more formal, but it would be nice if we could end our meetings with the four-way test, just to keep Rotary alive in our roots.
That's a good idea. Do you want to lead us in the four-way test of the things we think, say, and do?
Sure. Are you ready?
Ready.
Is it the truth?
Is it the truth?
Is it, is it
Fair to all
Fair
concerned.
to all concerned.
concerned? Will it build
Goodwill
and better
and
friendship?
better friendships.
Will it build goodwill and better friendships?
Is it beneficial to all concerned?
Is it beneficial to all concerned?
Had I been the one responsible for writing this 100 years ago, I think I would have changed the wording out a little bit.
Yeah,
Just saying.
The one thing I'll say, when we did this, as I said to somebody at another meeting this week, we did it a different way entirely.
How?
Same end result, same words, but we recited it differently. Lynn, do you want to give it a try?
Just to retest,
Yes, the Farmington Rotary way.
the four-way test of the things we think say or do. First, is it the truth? Second, is it fair to all? Third, will it be beneficial? I can't
I love it.
think of looking at the writing on the back of my here and that thing to do. Will it be beneficial to all concerned and will it build goodwill and better friendships?
Yeah. For us that are looking at the screen, that would have been a lot easier if we just read what was behind you. But I needed to have kept you on the screen. So it seems like we need some practice in order to be able to do that. So I expect you all to practice that for next time. And we will recite it the way that it is behind Lynn, Farmington Rotary style.
And for those that want the reminder, this I will have this on all future meetings. So. If you look real close.
Well, on my screen, because I use two screens, I can still see it behind you on the smaller screen, but when you come up big time, when you start talking, I can see it very clearly. I should have asked Sharna.
Well, I will add the fifth, which is having fun.
Yeah, I've heard that. I've heard it said that way.
Yeah,
will-
some clubs do the fifth one. Our club doesn't usually, but I've heard it at a number of clubs, having fun.
I've also heard it said one added, I'll try and paraphrase it at the very least. It was something like, have fun, hope you don't get caught.
And with that, I'll leave. Thank you, everyone.
That's a good idea.
With that, we should all leave.
Yes, please.
Okay, I'll
Have a
end it.
good week.
It'll be up on YouTube a little later today, probably.
Enjoy your week, everyone.
Okay, ciao.
Thank you, everybody.
Bye-bye.